Would I ever let my client testify in his own criminal case? Absolutely. Sometimes. Rarely. I'm a Los Angeles criminal defense trial lawyer, and sometimes putting my client on the stand can be the difference between a guilty and a not guilty. But before that happens, there are 5 things I need to know. Does the jury really need to hear from him? Sometimes they don't. If the prosecutor can't prove its case, why give them an opportunity to try to make my client look bad? But in a self-defense case, for example, sometimes the only person who can explain what my client saw, what he believed, and why he acted is my client himself. Can he handle cross-examination? Talking to me is easy. Sometimes. Most of the time. The real question is, what happens when a prosecutor gets in his face and starts accusing him of lying? Does he stay calm? Does he get defensive, angry, and start arguing? Unless I know he can keep his cool, I don't want him anywhere near the stand. Does this story make sense? Jurors have detectors. If the story doesn't make sense to 12 regular people, putting him under oath isn't going to magically fix it. Contrary to popular opinion, jurors aren't idiots. The last thing the lawyer will do is win by trying to insult their intelligence. What baggage comes with him? Prior convictions, prior statements, things he told the police. Before my client takes the stand, I need to know what doors his testimony will open. Sure, there are ways I can soften the blow, make the problems look not so bad, but sometimes you just can't. And number 1, do I believe the jury will like him? This is huge. Jurors aren't robots. They're judging credibility. Sometimes a client can sit at a counsel table for 2 weeks and the jury knows absolutely nothing about them. Then he takes the stand and suddenly he's a human being. They hear him, they understand him, they connect with him. I've had cases where putting my client on stand was a risk, but sometimes the bigger risk is never letting the jury hear from him at all.